Hey, part 2, same day, 11:22 a.m. The Queen's Justice in the Queen's Government, the independence of the judiciary, and my boomer uncle, you can see, has paper out of the Beatles, something, the Blue Meanie, I don't know what that is, and some fucking old didgeridoo. Well, they have this reverence for just Aboriginal shit. Maybe it's just in this family a little bit more than others. It's bizarre. It's literally just wood. Most of their shit is just carved wood. I don't know. Boomers are so gay. Independence of the judiciary. In the absence of a favourable public opinion, no constitutional formulae could protect the independence of the judiciary. The authority of Parliament is wide enough to destroy it at a blow. Nevertheless, the formulae, I need to know how to pronounce that, doesn't matter, you get the idea, have been devised. A judge of a superior court is appointed either by the Lord Chancellor, capitalised, or by the Prime Minister, capitalised, in consultation with the Lord Chancellor. Until recently, political considerations were not excluded. It can probably be said that not more than 3 cases of political influence have occurred in the past 50 years. Once appointed, though, the judge is utterly independent. He holds his office not at the pleasure of the Crown, like most royal officers, but, quote, during good behaviour. Possibly there is a legal remedy against a judge who misuses his office, but since the question has never risen in practice, the law is doubtful. The political remedy is a resolution by both houses of Parliament, and this remedy has never been used since it was laid down in the Act of Settlement, capitalised, in 1701. The judge's salary, too, is not voted annually like the salaries of most royal officers. It is, quote, charged on the consolidated fund like the Queen's civil list, capitalised. Nor may a judge be criticised in Parliament except on substantive motion. It follows that though Parliament can criticise... That painting is really distracting. Paper art is really distracting. Fuck this shit. Oh, God. Should actually have a proper background. It doesn't matter. You should only be listening, not watching. Oh, it was funny, the morning of my car was burned. Apparently the fire brigade was called. The police showed up just before I was to breakfast. I had salmon or something. It's a pretty bad breakfast. Difficult to eat given the distraction of the news. He told me this was a Manchester City, or asked if I knew, or asked if I was a fan of the team or something. CRTY. I never noticed it when I bought it. It's like a good acrylic thing, so it doesn't actually technically get wet because it's literally plastic. Yeah, I don't know. Not important. Judge's salary too is not voted annually like the salaries of most. I think we did that. This is really rambling. These constitutional devices not only protect judicial administration at lower levels, and yet judges and magistrates in inferior courts are equally independent. One reason which applies to all professional judges is that they are chosen from a profession which has been made independent, has made independence its motto. Judges are not civil servants belonging to the judicial branch of the public service. They are chosen from the bar, which is a long tradition of professional independence. So there is some merit or competence to this. As was mentioned earlier with the civil servants, or service, you have to take examinations, and you wouldn't be the best, but you would have a broad enough sort of education and ability, and most importantly I think it was judgment and an ability to sort of work with detail and work with minimal mistakes, with good deliberation and coordination, I think, was the key. Yeah. When they actually used to be public servants, technically. Now they're parasitic bureaucrats a lot. But anyway. Lawyers claim that they belong to the oldest profession, but one in the world. So, what's the other one? I don't want to mention it. That's profane. Possibly the claim is not justified, for the priests came before the lawyers. Okay. Bone shamans. Rock shamans. I don't know. Druids. I don't know what he's talking about. It can be said, though, that in England the bar, capital B on bar, is the oldest organised profession, whereas in most other countries the lawyers were university graduates. In England, the pleaders at the King's Courts at Westminster formed their own organisation and controlled the admission of their own members, so private. The capitalised Inns of Court began as mere unofficial organisations for communal living, like the colleges of Oxford and Cambridge. They gradually established a monopoly for the admission of, quote, utter barristers, barristers who plead outside the bar. The sergeants at law, who pleaded within the bar, received a patent from the Crown, but formed their own inn. Funny old terms. The judges of the Supreme Courts were appointed from among the sergeants and remained as members of the Sergeants' Inn. When the Order of Sergeants began to disappear, the judges were selected from among the King's Council. Barristers who received patents of precedence from the Crown, which required them to advise the Crown if need be. As such, they were entitled to plead within the bar, but they remained members of their own inns. The result is that the judges now remain in the inns which they entered as students, and by which they were called to the bar. The fraternity of the bar is very real. Fraternity, brotherhood, no women, I'm guessing. Which probably still is majorly the case. Reminds me of Ginsburg. That horrible cunt is... I don't know how she's still alive. They keep her corpse fresh or something. The fraternity of the bar is very real, and the barrister who submits, quote, submits with all respect in court need not be so respectful outside the court. There is professional opinion which carries weight. That opinion, too, strongly favours judicial independence. A subservient judge, a judge who bowed to political pressure or public opinion, could be condemned by his fellows in his own inn. Thus, judicial independence is secured by constitutional devices strengthened by professional opinion and founded on public opinion. Nor have the judges been backward in protecting themselves. For the last 250 years, at least, the judges have echoed Lord Coke's retort to James I that, quote, he would do what it was meet and judge should do. He would do what it was meet and judge should do. I don't know. They've held that no judge is liable for words spoken in the course of judicial administration unless he was acting outside of his jurisdiction, and the exception cannot apply to a superior judge because he has an unlimited jurisdiction. They have, too, developed the offence of contempt of court, which protects the judges from allegations of partiality or incompetence. The independence of the judiciary is thus secured by a network of constitutional devices and by the force of professional and public opinion. The allegation of partiality or corruption or political influence is ever made against British judges. They share the characteristic of the ordinary Englishman. They're not only independent, but truculent. I love that word, truculence. Truculently independent. I think it means stubborn or steadfast. Anybody who has the law on his side has his judges on his side. Whatever defects there may be in the law, the citizen is assured that it will be administered freely and fairly, without favour and without fear. So, restating of the first section. I think we'll leave it there. My voice and lips are a bit rough. And then we've got only a few pages. Oh shit. 6 pages maybe. We'll see how that goes. Part 3 soon.